Hello everyone, welcome back to Wills, Trusts and More. And of course we have Eileen back with us. Eileen Kerlin Walsh is an attorney here in Worth. She is located at 11301 South Harlem. We're going to put her number at the bottom of the screen. She has some very interesting topic to talk about today. If you have some questions, we'll have as I said, we'll have the number at the bottom of the screen so you can call her and we'll go from there. Today is talking about fiduciary planning. What does the word mean for the sake of the viewers? What is meant by that?
Thank you, Ron. This is a very fancy word, fiduciary, and you see it in financial planning and estate planning all the time. A fiduciary just means someone, very specific term, that you entrust with your care, with the care of yourself, your finances, your health care. Someone who takes on the responsibility for that, someone who takes on the liability for that, and will take care of those duties that you determine during your lifetime and afterwards.
Okay, what is the total role? Is it basically what you've just recited for this person?
Well, a fiduciary typically is either an agent for healthcare, an agent for finance. Very typically, it's a trustee or an executor. So your fiduciary can act in all of those. Even a guardianship is considered that role, though with a guardianship, we have court involvement, and if we do our planning in time, we can usually try to keep the courts out of our lifetime and after death planning. Fiduciary duties often include paperwork. They could include document gathering, getting everything together, filings, accounting. It can include hiring professionals, liaising with professionals, accountants, attorneys. It can involve taking care of you during your lifetime, making decisions about your living arrangements. All of this fiduciary business comes up at the time that we're no longer able to take care of ourselves. So it's who is going to make the decisions then. Where should we live? Do we need to transition to assisted living? Does real estate need to get sold? Even help with the transition at the end, funeral, burial, settling of the estate, taking care of the beneficiaries, making sure that everything is done equally, everyone is treated equally in compliance with the law. Tremendous responsibility. And that's why the choice of who your fiduciary should be is so important, Ron.
So the person really, in layman's terms, is for the well-being of you or a person.
Absolutely. The well-being.
In very general terms.
In very general terms, the person who's going to step into your shoes and do the very best for you, act in your best interest, do everything that if you were still able, you would do yourself. And if we choose wisely now, while we're healthily incompetent, that's just the buzzword of the show, we can avoid some of the horror stories we hear. We hear horror stories of abuse of assets, you know, even abuse of the care of an elderly person. You hear about huge family rows, blow-ups, estrangements. There are so many things that can go wrong, and what we hope to do today is talk about the choices, how to direct your estate, and how to choose so that none of those things is going to happen to you.
Okay. Is there a conversation that you could share with us about the pros and cons of having one in the family become that person?
Excellent question, because that's where my clients, where most people, when they're doing their estate plan, that's where they go. Let's get a family member. There's many advantages to having a family member. It's somebody we know, somebody we love, someone we trust, someone who's already familiar with us, our routines, our care, our pets, our home, our finances. We don't have to give up our privacy. So there's a lot of good reasons and understandable reasons why that's where a parent's first thoughts go. But what we can do is help people re-examine that. Now, it may still very well be your children you name, but let's look at what's involved. Are those children going to be able to make those decisions? Do we even have the people in the state? You know, maybe people are very far away. So we've got to look at the disadvantages of naming family members. Now, it's a lot less expensive to name a family member, and usually loving sons or daughters will step up to the job. But I'll tell you something, Ron, after many years of doing estate planning, I have never had an executor or a trustee say they love the job. They often find it really difficult. They'll often deny themselves compensation, even though we always include room for it in the documents, out of guilt because their parent took care of them, now they should be taking care of their parent. They sometimes get burdened with the responsibilities. Then other siblings are sometimes looking on thinking, well, what are they doing? You know, are they handling our parents' money wisely?
Exactly.
So they can end up, you know, in either fights with siblings or estranged, having lost the love and trust of their siblings, feeling a little burdened, feeling a little wore down by the responsibility, and ultimately maybe the parents sense that the child was the right way to go may not necessarily be right for them or for the child. So it's good for parents to know that there are options, and that's where the professional trustee comes in.
For the viewers, I will personally vouch for everything she just said. I'm involved with it, and I can understand exactly what you just said. Now let's go out of the family. What about a professional person? Is there advantages or disadvantages to that? And share that with us.
Absolutely. And as with everything in the law and life, there's benefits and burdens, and it's a matter of doing that weighing and determining the best direction for you. Professional trustees are a wonderful option. Right off the bat, they're objective. They're not emotional. They're not going to fall out with anyone. They know what they're doing. They can comply with the documents. They do this all the time. They're not having to juggle. Hopefully nothing will fall through the loopholes. They are familiar with state law, federal law. Professional trustees are a really good option. What are the downsides? They typically are more expensive than having a family member. They can sometimes have a yearly fee depending on the size of the estate. So occasionally, the larger trust companies will not take an estate that's below a certain value. Some of the larger houses will only take an estate that's worth 1 or 2 million. So there are smaller, more local trust companies that may take a smaller estate, may be less expensive. So there are a lot of options with the professional trustee. Another downside that you may think about when it comes to a professional trustee is that it may be a little impersonal. If during your lifetime you have a nice living trust and you start to need the help, are you going to have to go through a call center? Is the professional trustee even in your state? So it can feel a little impersonal. And even if you do get someone who knows your story and you don't have to tell it over and over again, it's a large corporation, so somebody could get promoted, someone could leave.
Yeah, and then it leaves you a very cold feeling, doesn't it?
A little bit, and that exactly segues Ron to another option, that you really don't have to deal with the larger houses. Now, I cannot say enough good things about the larger trust companies. They do terrific work. One of the disadvantages of them also that some clients find is that they tend to keep the investments in-house. So if you're very familiar with your CPA, your financial planner.
There's an encouragement factor there.
Absolutely. They're much more likely to move your investments. And again, they do a great job or they wouldn't exist, and they're very well regulated and insured. But there are those disadvantages. Now, there is another terrific option that's kind of a little bit of a hybrid. There are many small trust companies, private trust companies, sometimes down to 1 or 2 people who will be professional. This is what they do full time, but they often tend to be less expensive. They often tend to be easier to get a hold of. They're local. And another wonderful advantage is, and I have used this for my clients time after time, is that they will often expand the services. They'll do power of attorney for finance and healthcare. Also, the big houses are never going to be able to do that. They will even act as standby guardian. So if we have a client who maybe has a disabled adult child and their big concern is the care of that child after their death, to be able to name one of these local trusted companies that they can get to meet now to take over as standby guardian and to fill in many of the roles is a huge advantage. So, and they do tend to be less expensive and a little bit more personal and much more likely to work with your CPA, your attorney, and your financial advisors because they are independent. So a personal, smaller professional company is a great option also.
And I know personally there are some local banks that would provide that service also.
Great point. The local bank is a great choice. It has a lot of that flavor of the smaller company as well, but it's also the bank. And we know the bank will always have a succession plan. We know the bank's always going to be insured. The only little bit of doubt that hangs over the local bank is that we know what happens successful local banks. And usually the better they are and the more successful they are, they tend to get taken over by the big conglomerate.
Yes,
that'll
yes.
sell off the trust department, and then you may not have that local flavor and that local contact that you did enjoy. To go back to that smaller company, you always have to make sure, if you do name a small private fiduciary company, that they have backup, that there's coverage, that if they fold or if they go out of business or if they retire, who's taken over, making sure that they have a succession plan. So the rule of thumb really is, whichever one of these directions you go on, do your homework now. Make your decision based on what you know about the company, what you know about your family, what you know about your assets, your research into these companies, so you know exactly what you're getting and you can make the choice that's best for you.
For the reason that you mentioned about the banks, a small private company, how does one even find a small private company to select from, and maybe have 2 or 3 to interview and try to get an understanding what their services are and their history?
Yeah, and that's something that's where really your trusted advisor will come in. We as estate planners make it our business to have these on file for when our clients need them.
That's very important.
Any seminar we go to, the organizations that we belong to, we will always meet these organizations who know that it's us who are going to refer them. And before we refer one of those companies, we will have the representatives of their office come meet with us so that we know we can refer them. We will have them meet with the client. I have clients right now meeting with a company to see if they can get a comfort level to work together. So I am always keeping my fiduciary duties to my clients to make sure that the representation that I'm giving them is in their absolute best interest. So we would not make a recommendation lightly. And I have not seen abuse of trust duties by any professional, be it a large, huge company that's out of state or a very small bank or one of these private companies. To be honest, Ron, any abuse or neglect I see is with the family member. And that is just those couple, and we've seen many, many competent family members be able to do this. They work tirelessly. They often work without compensation. But occasionally, if there's going to be that glitch, if there's going to be a gap in service, and if something's going to go wrong, it's more likely to happen with an inexperienced family member named as an executor or a trustee rather than these professional companies. And the cost is a factor. I never minimize that. And that is often too why the size of the estate that the client have will make the determination. If they have a larger estate, it needs more sophisticated planning and management, and it is better able to handle the fees that a professional trustee will have. So the size of the estate is a big factor, as well as that particular client's family situation, who they have. And not everybody, and I know we've said this many times, Ron, not everyone has the children. Some people don't have children at all. Some are estranged. And I have heard, I cannot tell you, I often have heard, I trust my son, but not his wife. I trust my daughter, but I'm not so sure about my son-in-law. And knowing that they work closely together, the parent feels that they would be placing their care in both those hands, their loved one and the in-laws. So that is often where the difficulty arises, and it's not even bad faith. It's sometimes just lack of experience in this field, plus the emotional quality. And one of the wonderful aspects of a professional trustee is the detachment, the objectivity, in addition to their experience in understanding these types of documents and having done this many times before. It's a lot easier for a professional trustee to say no, the next payment's not for 5 years, than for the brother or sister to say it.
Right. Now, to back up just a little bit, you were saying, of course, there are fees involved. If a family member is an executor, wouldn't they justify a fee for handling all the affairs that you just recited?
Absolutely. We always ask the client if they want to include that provision. And we always recommend it because certainly there's a lot of work and a lot of hours involved. So be it as a power of attorney, as a trustee, as an executor, when we draft the documents, we always say they're entitled to reasonable compensation. That word reasonable makes sure that they're not taking, you know, a percentage of the estate, that it's usually, the last time reasonable was litigated, it was $50 per hour. So depending on the complexity of the estate and the amount of work involved, family members should get compensated. And I personally think that if they do take compensation, they're much less likely to get that sense of being burdened and weighed down and too much responsibility that's maybe not appreciated by the parents and the other siblings. So absolutely, they should get compensated. Often they don't take it because this little sense of, I should be taking care of my parents or my grandparents because they took care of me.
Right.
So the professional trust companies have no such qualms when it comes to receiving payment, shall we just say.
Okay, let's talk about co-executors and co-trustees sharing the load.
Oh, such a sensitive, such a controversial subject. Parents often feel, out of a sense of love and not wanting to make a difference between their children, will say, oh, we'll just name them all, or we'll name our 2 daughters as co-trustees, or we have 3 children, how about they all be co-trustees or co-executors? And I'll often say, yes, we could do that, but should we do that? And we really have to consider, what are we doing? One of the ideas of these fiduciaries is that someone has ultimate authority and responsibility, can step into their shoes, has legal authority to get the job done. If we give it to 3 people, those 3 people have to agree unanimously on every decision. That is really going to clog up things getting done because it's hard to agree. We can barely agree with our spouse, you know, on 100% on every decision.
Exactly. And every document, every legal document that requires a signature has to go by the co-executors. If there are 3, you need 3 signatures.
Absolutely.
If there are 2, you need 2 signatures.
State to state, country to country, wherever those people are. So that's cumbersome. It's difficult to get unanimous decision. I have found that if we have several trustees, if they're co's and it's working, it's usually because the dominant one has taken over and the others just, where do I sign? They just follow. Yeah. Because for all those siblings, and especially when it's siblings, and especially when it's mom and dad.
Yes.
Those are so emotional, those issues. It's even harder to agree on that than on where to go for dinner. So because of the difficulty of co-trustees agreeing, or co-executives, you cannot have co-agents under the healthcare and financial powers, thankfully. So therefore we never have to worry about that. Because of those very specific difficulties, parents should think, now they're always the architect, and if they want to name co's, then ultimately they get to make that decision. But we can tell our clients that it often leads, it's a little misguided, and they do it so as not to make a difference between their children and not have the children feel that one was chosen of the other. It's much more likely to have the children disagree and maybe fall out. And another thing we've often said, Ron, here is that parents are the glue that hold children together. There's a loss of some of that when parents are gone anyhow.
Definitely.
And if there's something in the estate to fight about, there's even more possibilities. So I've said this many times before, really take seriously my role in promoting family harmony after the parents are gone, because I know that's part of what they want. That's part of what they want to leave their children and grandchildren. So no co's if at all possible. Another thing parents will sometimes say, well, how about if we have a co between a family member and a trustee? Doesn't that give us, a professional trustee? Does that give us the best of both worlds? But sometimes you get the worst of both worlds, because sometimes you get the professional trustee who has to be paid and a family member who has to agree, may not understand what the professional trust company is doing, may need a lot of coaching, and therefore that's taking more time from the professional trustees. Well, it's taking more time and therefore costs more money. If checks and balances are absolutely necessary, by all means use that as an option. But it can, as with every other choice, have its pitfalls. So just become informed, get educated, and choose wisely.
In closing, anything more you want to summarize? You should be doing something about this as quickly as you can, and you're not too young to do it.
No, and I'll tell you, Ron, one of the things that keeps people from estate planning other than, I don't want to think about death, I don't want to think about mortality, I don't even want to think about disability. But one of the difficult things is coming up with these people. And I will often say to clients when they're thinking about coming to the appointment, give some thought to who your agents would be and try not to just divvy out the roles. Sometimes parents will say, well, I give someone power of attorney, so I'm going to give somebody else health care, you know. And the same with executors and trustees. But we always say, make the right decision for your estate plan. Make the right decision for your beneficiaries. And someone is much less likely to fall out because they weren't chosen as a trustee than if there was an unequal distribution. So as long as your distribution is equitable according to what you want, again, you're the captain, who you choose as fiduciaries is just to get a job done. So the more unemotional you can be about that decision, the better. And we are choosing these fiduciaries for a time when you are unable to make the decision yourself. So that's why, Ron, we always end on the topic of get it done now when you're most healthy and most competent, and tuck it away until all the years pass, until that day comes when you might need it.
Right. Very good. Lots of information. You did an excellent job of sharing it, some of which involved me personally, so I have to vouch for what you have said is right on the money. So I thank you for that. And for the viewers who do not have an attorney or a legal person that you need to share this with, I suggest you give Eileen a call. Her number is at the bottom of the screen, 708-448-5169, and she'd be happy to answer your questions and maybe meet with you and go from there.
Absolutely.
Eileen, thank you again.
Thank you, Ron.
We'll be seeing everyone watching in a few weeks again with another topic.
That's excellent. We'll be here. Thank you.
Okay.
Thank you.
Have a good day.